Remedial Law Q&A 2019. Q. A files an action in the municipal trial court against B, the natural son of A's father, for the partition of a parcel of land located in Taytay, Rizal, with an assessed value of 2,000 pesos. B moved to dismiss the action on the ground that the case should have been brought in the regional trial court because the action is one that is not capable of pecuniary estimation, as it involves primarily a determination of hereditary rights and not merely the bare right to real property. Resolve the motion. Answer. The motion should be granted. The action for partition depends on a determination of the hereditary rights of A and B, which is not capable of pecuniary estimation. Hence, even though the assessed value of the land is 20,000 pesos, the municipal trial court has no jurisdiction. Russell v. Bastille. Q. Does the Court of Appeals have jurisdiction to review the decision in criminal and administrative cases of the Ombudsman? Asked in 2006. Suggested answer. The Court of Appeals can only review the decisions of the Ombudsman in administrative cases in an appeal by petition for review under Rule 43 of the 1997 Revised Rules of Civil Procedure. It has no jurisdiction to review decisions of the Ombudsman in criminal cases, the proper remedy being to file with the Supreme Court an original petition for certiorari under Rule 65. Fabian v. Ombudsman Desierto, Quezon v. Ombudsman Desierto, and Mendoza Arce v. Ombudsman. Q. An amicable settlement was signed before Alupon Tagapamayapa on January 3, 2001. On July 6, 2001, the prevailing party asked Alupon to execute the amicable settlement because of the non-compliance by the other party of the terms of the agreement. The Lupon concerned refused to execute the settlement or agreement. A. Is the Lupon correct in refusing to execute the settlement or agreement? Letter B. What should be the course of action of the prevailing party in such a case? Suggested answer to letter A. Yes, the Lupon is correct in refusing to execute the settlement or agreement because the execution sought is already beyond the period of 6 months from the date of the settlement within which the Lupon is authorized to execute. Section 417, Local Government Code of 1991. Letter B. After the 6-month period, the prevailing party should move to execute the settlement or agreement in the appropriate city or municipal trial court. Q. What is the rule on joinder of causes of action? Letter B. A secured 2 loans from B, one for 500,000 and the other for 1 million pesos payable on different dates. Both have fallen due. Is B obliged to file only one complaint against A for the recovery of both loans? Explain. Suggested answer. Letter A. The rule on joinder of causes of action is that a party may in one pleading assert, in the alternative or otherwise, as many causes of action as he may have against an opposing party, provided that the rule on joinder of parties is complied with. The joinder shall not include special civil actions or actions governed by special laws, but may include causes of action pertaining to different venues or jurisdictions, provided one cause of action falls within the jurisdiction of a regional trial court and venue lies therein, and the aggregate amount claimed shall be the test of jurisdiction, where the claims in all the causes of action are principally for the recovery of money. Letter B. No joinder is only permissive since the loans are separate loans which may be governed by the different terms and conditions. The 2 loans give rise to 2 separate causes of action and may be the basis of 2 separate complaints. Q. PJ engaged the services of attorney ST to represent him in a civil case filed by OP against him, which was docketed as civil case number 123. A retainership agreement was executed between PJ and attorney ST, whereby PJ promised to pay attorney ST a retainer sum of 24,000 a year and to transfer the ownership of a parcel of land to attorney ST after representing or presenting of PJ's evidence. PJ did not comply with his undertaking. Attorney ST filed a case against PJ, which was docketed as civil case number 456. During the trial of the civil case number 456, PJ died. Q. Is the death of PJ a valid ground to dismiss the many claim of attorney ST in civil case number 456? Explain. Letter B. Will your answer be the same with respect to the real property being claimed by attorney ST in civil case number 456? 2000. Suggested answer to letter A. No. Under Section 20, Rule 3 of 1997 Rules of Civil Procedure, when the action is for recovery of money arising from contract, express or implied, and the defendant dies before entry of final judgment in the court in which the action is pending at the time of such death, it shall not be dismissed, but shall instead be allowed to continue until entry of final judgment. A favorable judgment obtained by the plaintiff shall be enforced in the manner specially provided in the rules of prosecuting claims against the state of a deceased person. Letter B. Yes, my answer is the same. An action to recover real property in any event survives the death of the defendant. That is in Section 1, Rule 87, Rules of Court. However, a favorable judgment may be enforced in accordance with Section 7, letter B, Rule 39 of the 1997 Rules of Civil Procedure against the executor or administrator or successor in interest of the deceased. Q. Distinguish a derivative suit from a class suit. Suggested answer. A derivative suit is a suit in equity that is filed by a minority shareholder in behalf of a corporation to redress wrongs committed against it, for which the directors refused to sue, the real party in interest being the corporation itself. Lim versus Lim U. A class suit is filed in behalf of many persons, so numerous that it is impracticable to join all as parties. Q. Real action and personal action. Real action refers to an action when it affects title to or possession of a real property or an interest therein. Personal action is an action when a personal property is sought to be recovered or where damages for breach of contract are sought. Explain each mode of certiorari, 2006 bar, as a mode of appeal from the original trial court or the Court of Appeals to the Supreme Court. A petition for review on certiorari under Rule 45 of the 1997 Revised Rules on Civil Procedure is a mode of appeal on pure questions of law from a judgment or final order or resolution of the Court of Appeals or the Regional Court to the Supreme Court. Explain each mode of certiorari. As a mode of review of the decision of the National Labor Relations Commission and the Constitutional Commission. Suggested answer. The mode of review of the decision of the NLRC is via a special civil action for certiorari under Rule 65, but pursuant to the hierarchy of the courts enunciated in the case of St. Martin's Funeral Homes versus NLRC. The same should be filed in the Court of Appeals. The mode of review of the decision of two constitutional commissions, the Commission on Elections and the Commission on Audit, as provided under Rule 64 of the 1997 Revised Rules of Civil Procedure, is a special civil action for certiorari under Rule 65. Decisions of the Civil Service Commission, however, are reviewable by petition for review to be filed with the Court of Appeals under Rule 43 of the 1997 Revised Rules of Civil Procedure. Q. May the aggrieved party file a petition for certiorari in the Supreme Court under Rule 65 of the 1997 Rules of Civil Procedure instead of filing a petition for review on certiorari under Rule 45 thereof for the nullification of a decision of the Court of Appeals in the exercise either of its original or appellate jurisdiction? Asked in 2005. Suggested answer: the remedy to nullify a decision of the Court of Appeals is a petition for review on certiorari in the Supreme Court under Rule 45 instead of a petition for certiorari under Rule 65, except in certain exceptional circumstances such as where appeal is inadequate. For settled jurisprudence, certiorari is not a substitute for a lost appeal. Q. For failure of KJ to file an answer within the reglementary period, the court, by motion of LM, declared KJ in default. In due time, KJ filed an unverified motion to lift the order of default without an affidavit of merit attached to it. KJ, however, attached to the motion his answer under oath, stating in said answer his reasons for his failure to file an answer on time, as well as his defenses. Will the motion to lift the order of default prosper? Explain. Suggested answer: yes. There is substantial compliance with the rule. Although the motion is unverified, the answer attached to the motion is verified. The answer contains what the motion to lift the order of default and the affidavit of merit should contain, which are the reasons for movant's failure to answer as well as his defenses. Section 3, letter BJ of Rule 9, 1997 Rules of Civil Procedure, Citibank, N.A. versus Court of Appeals. Q. In an Admiralty case filed by A against Y Shipping Lines, whose principal offices are in Manila, in the Regional Trial Court, Davao City, the court issued a subpoena duces tecum, directing Y, the president of the shipping company, to appear and testify at the trial and to bring with him several documents. Letter A. On what valid ground can Y refuse to comply with the subpoena duces tecum? B. How can A take the testimony of Y and present the documents as exhibit other than through the subpoena from the Regional Trial Court? Answer. Y can refuse to comply with the subpoena duces tecum on the ground that he resides more than 50, now 100 kilometers from the place where he is to testify. Letter B. A can take the testimony of Y and present the documents as exhibits by taking his deposition through oral examination or written interrogatories. Rule 24, New Rule 23. The other rule is Section 10 of New Rule 21. He may also file motion for the production of or inspection of documents. Rule 27. Alternative answer. The witness can also refuse to comply with the subpoena duces tecum on the ground that the documents are not relevant and there was no tender of fees for 1 day's attendance and the kilometerage allowed by the rules. Q. AB as mother and in her capacity as legal guardian of her legitimate minor son, CD, brought action for support against EF as father of CD and AB's lawfully wedded husband. EF filed his answer denying his paternity with counterclaim for damages. Subsequently, AB filed a manifestation in court that in view of the denial made by EF would be futile to pursue the case against EF. AB agreed to move for the dismissal of the complaint, subject to the condition that EF will withdraw his counterclaim for damages. MB and EF filed a joint motion to dismiss. The court dismissed the case with prejudice. Later on, minor son CD, represented by AB, filed another complaint for support against EF. EF filed a motion to dismiss on the ground of res judicata. Is res judicata a valid ground for dismissal of the second complaint? Explain. What are the essential requisites of res judicata? Letter B. Suggested answer to letter A, no. Res judicata is not a defense in an action for support, even if the first case was dismissed with prejudice on a joint motion to dismiss. The plaintiff's mother agreed to the dismissal of the complaint for support in view of the defendant's answer denying his paternity with a counterclaim for damages. This was in the nature of a compromise of the right of support, which is prohibited by law. Article 2035 Civil Code, De Assis versus Court of Appeals. Letter B. The essential requisites of res judicata are: 1. The judgment or order rendered must be final. 2. The court rendering the same must have jurisdiction of the subject matter and of the parties. 3. It must be a judgment or order on the merits. And 4. There must be between the two cases identity of parties, identity of subject matter, and identity of causes of action. San Diego versus Cordona. After defendant has served and filed his answer to plaintiff's complaint for damages before the proper regional trial court, plaintiff served and filed a motion with supporting affidavits for a summary judgment in his favor upon all of his claims. Defendant served and filed his opposition with supporting affidavits to the motion, and after due hearing, the court issued an order, number 1, stating that the court has found no genuine issue as to any material fact and thus concluded that plaintiff is entitled to judgment in his favor as a matter of law, except as to the amount of damages recoverable. And number 2, accordingly, ordering the plaintiff shall have judgment summarily against defendant for such amount as may be found due plaintiff for damages, to be ascertained by trial on October 7, 2004 at 8:30 in the morning. May defendant properly take an appeal from said order, or may defendant properly challenge said order through a special civil action for certiorari? 2004. Suggested answer, no. Plaintiff may not properly take an appeal from said order because it is an interlocutory order, not a final and appealable order, Section 4 of Rule 35. It does not dispose of the action or proceeding, Section 1 of Rule 39. Partial summary judgment are interlocutory. There is still something to be done, which is the trial for the adjudication of damages, Province of Pangasinan versus Court of Appeals, Guevara versus Court of Appeals, but the defendant may properly challenge said order through a special civil action for certiorari, Section 1, letter C, and last paragraph of Rule 41. Q. Defendant X received an adverse decision of the Regional Trial Court in an ordinary civil case on the 2nd of January, 2003. He filed a notice of appeal on the 10th of January of the same year. On the other hand, Plaintiff A received the same decision on the 6th of January, 2003, and on 19 January 2003, filed a motion for reconsideration of the decision. On 13th of January 2003, Defendant X filed a motion withdrawing his notice of appeal in order to file a motion for new trial, which he attached. On January 20th, 2003, the court denied A's motion for reconsideration and X's motion to withdraw notice of appeal. Plaintiff A received the order denying his motion for reconsideration on the 3rd of February and filed his notice of appeal on the 5th of February. The court denied due course to A's notice of appeal on the ground that the period to appeal had already lapsed. Is the court correct? Is the court's denial of X's motion to withdraw notice of appeal proper? Letter B. Is the court's denial of due course to A's appeal correct? 2003. Suggested answer to letter A, no. The court's denial of X's motion to withdraw notice of appeal is not proper because the period of appeal of X has not yet expired. From January 2, 2003, when X received a copy of the adverse decision up to January 13, when he filed his withdrawal of appeal and motion for new trial, only 10 days had elapsed and he had 15 days to do so. Letter B, the answer is still no. The court's denial of due course to A's appeal is not correct because the appeal was taken on time. From January 6, 2003, when A received a copy of the decision up to January 19, when he filed a motion for reconsideration, only 12 days had elapsed. Consequently, he had 3 days from receipt on February 3 of the order denying his motion for reconsideration within which to appeal. He filed his notice of appeal on February 5 or only 2 days later. Alternative answer, letter B. Since A's motion for reconsideration was filed on January 19, 2003 and it was denied on January 20th, it was clearly not set for hearing with at least 3 days' notice. Therefore, the motion was pro forma and did not interrupt the period of appeal, which expired on January 21, 2003 or 15 days after notice of the decision on January 6, 2003. Q. May the aggrieved party file a petition for certiorari in the Supreme Court under Rule 65 of the 1997 Rules of Civil Procedure instead of filing a petition for review on certiorari under Rule 45 thereof for the nullification of a decision of the Court of Appeals in the exercise either of its original or appellate jurisdiction? Suggested answer is the remedy to nullify a decision of the Court of Appeals is a petition for review on certiorari in the Supreme Court under Rule 45 instead of a petition for certiorari under Rule 65, except in certain exceptional circumstances such as where appeal is inadequate. By settled jurisprudence, certiorari is not a substitute for a lost appeal. Q. Mario was declared in default, but before judgment was rendered, he decided to file a motion to set aside the order of default. Letter A. What should Mario state in his motion in order to justify the setting aside of the order of default? B. In what form should such motion be? 2001. Letter A. In order to justify the setting aside of the order of default, Mario should state in his motion that his failure to answer was due to fraud, accident, mistake, or excusable negligence and that he has a meritorious defense. Section 3, letter B of Rule 9, 1997 Rules of Civil Procedure. Letter B. The motion should be under oath. Q. When may a party be declared in default? Suggested answer. A party may be declared in default when he fails to answer within the time allowed therefor and upon motion of the claiming party with notice to the defending party and proof of such failure. Section 3, Rule 9. Effect of an order of default. Effect of a partial default being declared in default does not constitute a waiver of all rights. However, the following right is considered waived. Letter A. Be cited and called to testify as a witness. File a motion for new trial. Letter C. Participate in deposition taking of witnesses of adverse party. And D. File a petition for certiorari. This was asked in 2012 bar. Q. What is the effect of an order of default? Suggested answer. The effect of an order of default is that the court may proceed to render judgment granting the claimant such relief as his pleading may warrant, unless the court in its discretion requires the claimant to submit evidence. The party in default cannot take part in the trial but shall be entitled to notice of subsequent proceedings. Section 3, letter A, Rule 9 of the 1997 Rules. For failure to seasonably file his answer, Despite due notice, A was declared in default in a case instituted against him by B. The following day, A's mistress, who is working as a clerk in the sala of the judge before whom his case is pending, informed him of the declaration of default. On the same day, A presented a motion under oath to set aside the order of default on the ground that his failure to answer was due to fraud and he has a meritorious defense. Thereafter, he went abroad. After his return a week later, with the case still undecided, he received the order declaring him in default. The motion to set aside default was opposed by B on the ground that it was filed before A received notice of his having been declared in default, citing the rule that the motion to set aside may be made at any time after notice but before judgment. Resolve the motion. Suggested answer. Assuming that the motion to set aside complies with the other requirements of the rule, it should be granted although such a motion may be made after notice but before judgment. Section 3, letter B of Rule 9, with more reason, may be filed after discovery, even before receipt of the order of default. Describe briefly at least 5 modes of discovery under Rules of Court. 2000 bar. Suggested answer. 5 modes of discovery under the Rules of Court are 1. Deposition. By leave of court after jurisdiction has been obtained over any defendant or over property which is the subject of the action, or without such leave, after an answer has been served, the testimony of any person, whether a party or not, may be taken at the instance of any party by deposition of an oral examination or written interrogatories. Section 1, Rule 23 of the 1997 Rules of Civil Procedure. Number 2, interrogatories to parties. Under the same conditions specified in Section 1 of Rule 23, any party shall file and serve upon any adverse party written interrogatories regarding material and relevant facts to be answered by the party served. Rule 1, Section 1, Rule 25. Number 3, admission by adverse party. At any time after issues have been joined, a party may file and serve upon any other party a written request for the admission by the latter of the genuineness of any material and relevant document, or of the truth of any material and relevant matter of fact. Section 1, Rule 26. Number 4, production or inspection of documents or things. Upon motion of any party showing good cause therefor, a court may order any party to produce and permit the inspection and copying or photographing of any designated documents, etc., or order any party to permit entry upon designated land or property for inspecting, measuring, surveying, or photographing the property or any designated relevant object or operation thereon. Section 1, Rule 27. Number 5, physical and mental examination of persons. In an action in which the mental or physical condition of a party is in controversy, the court in which the action is pending may in its discretion order him to submit to a physical or mental examination by a physician. Section 1, Rule 28, 1997 Rules of Procedure. In an Admiralty case filed by A against Y Shipping Lines, whose principal office are in Manila, in the regional trial court of Davao City, the court issued a subpoena desus tecum directing Y, the president of the shipping company, to appear and testify at the trial court to bring with him several documents. A. On what valid ground can Y refuse to comply with the subpoena desus tecum? Letter B. How can A take the testimony of Y and present the documents as exhibits other than through the subpoena from the regional trial court, 1997? This is a repeat. Answer to letter A. Y can refuse to comply with the subpoena desus tecum on the ground that he resides from more than 50, now 100 kilometers from the place where he is to testify. That is in section 2021 now. Letter B, A can take the testimony of Y and present the documents as exhibits by taking his deposition through oral examination or written interrogatories. Rule 23. He may also file a motion for the production or inspection of documents. Rule 27. Alternative answer. The witness can also refuse to comply with the subpoena desus tecum on the ground that the documents are not relevant and there was no tender of fees for 1 day's attendance and the kilometrage allowed by the rules. The trial court rendered judgment ordering the defendant to pay the plaintiff moral and exemplary damages. The judgment was served on the plaintiff on October 1, 2001, and on the defendant on October 5, 2001. On October 8, 2001, the defendant filed a notice of appeal from the judgment, but the following day, October 8, 2001, the plaintiff moved for the execution of the judgment pending appeal. The trial court granted the motion upon the posting by the plaintiff of a bond to indemnify the defendant for damages it may suffer as a result of the execution. The court gave as a special reason for its order the imminent insolvency of the defendant. Is the order of execution pending appeal correct? Suggested answer, no, because awards for moral and exemplary damages cannot be the subject of execution pending appeal. The execution of any award for moral and exemplary damages is dependent on the outcome of the main case. Liabilities for moral and exemplary damages as well as the exact amount remain uncertain and indefinite pending resolution by the Court of Appeals or Supreme Court. RCPI versus Lantin, International School versus Court of Appeals. Alternative answer, yes, because only moral and exemplary damages are awarded in the judgment and they are not dependent on other types of damages. Moreover, the motion for execution was filed while the court had jurisdiction over the case and was in possession of the original record. It is based on good reason, which is the imminent insolvency of the defendant. Rule 39, Section 2. Q. May an order denying the probate of a will still be overturned after the period to appeal therefrom has lapsed? Why? Letter B. What should the court do if, in the course of intestate proceeding, a will is found and it is submitted for probate? Suggested answer to letter A, yes. An order denying the probate of a will may be overturned after the period of appeal therefrom has lapsed. A petition for relief may be filed on the grounds of fraud, accident, mistake, or excusable negligence within a period of 60 days after the petitioner learns of the judgment or final order and not more than 66 months after such judgment or final order was entered. Rule 38, Sections 1 and 3, Soriano versus Igasao. An action for annulment may also be filed on the ground of extrinsic fraud within 4 years from its discovery and if based on lack of jurisdiction before it is barred by laches or estoppel. Rule 47, Sections 2 and 3. Letter B. If a will is found in the course of intestate proceedings and it is submitted for probate, the intestate proceedings will be suspended until the will is probated. Upon the probate of the will, the intestate proceedings will be terminated. Rule 32, Section 1. Question A. What are the grounds for judgment on the pleading? Letter B. A's answer admits the material allegations of B's complaint. May the court motu proprio render judgment on the pleadings? And letter C. A brought an action against her husband B for annulment of their marriage on the ground of psychological incapacity. B filed his answer to the complaint admitting all the allegations therein contained. May A move for judgment on the pleading? Explain. Suggested answer on letter A. The grounds for judgment on the pleadings are when an answer fails to tender an issue or otherwise admits the material allegations of the adverse party's pleading. Letter B. No, a motion must be filed by the adverse party. Section 1, Rule 34. The court cannot motu proprio render judgment on the pleadings. And letter C. No, because even if B's answer to A's complaint for annulment of their marriage admits all the allegations therein contained, the material facts alleged in the complaint must always be proved. Q. When is there a judgment based on pleadings? Answer. Where an answer fails to tender an issue or otherwise admits the material allegations of the adverse party's pleading, the court may, on motion of the party, direct judgment on such pleading. Note, judgment must be on motion of the claimant. It cannot be rendered by the court motu proprio. Q. As counsel for A, B, C, and D, Attorney XY prepared a complaint for recovery of possession of a parcel of land against Z. Before filing the complaint, XY discovered that his clients were not available to sign the certification of non-formed shopping. To avoid further delays in the filing of the complaint, XY signed the certification and immediately filed the complaint in court. Is XY justified in signing the certification? Asked in 2000. Suggested answer is no. Counsel cannot sign the anti-form shopping certification because it must be executed by the plaintiff or principal party himself. Rule 7, Section 5. Procedure. Escorpizo versus University of Baguio. Since the rule requires personal knowledge by the party executing the certification, unless counsel gives a good reason why he is not able to secure his client's signatures and shows that his clients will be deprived of substantial justice, Ortiz versus Court of Appeals, or unless he is authorized to sign it by his clients through a special power of attorney. Q. Julio filed a complaint in the Municipal Trial Court of Lanusa for the recovery of a sum of money against Juan. The latter filed his answer to the complaint, serving a copy thereof on Julio after the filing of the answer of Juan, whose duty is to have the case set for pre-trial. Why? Suggested answer. After the filing of the answer of Juan, the plaintiff has the duty to promptly move ex parte that the case be set for pre-trial. Section 1, Rule 18. The reason is that it is the plaintiff who knows when the last pleading has been filed, and it is the plaintiff who has the duty to prosecute. Alternative answer. In the event that the plaintiff files a reply, his duty to move that the case be set for pre-trial arises after the reply has been served and filed. Q. Can a suit for injunction be amply filed with the Supreme Court to stop the President of the Philippines from entering into a peace agreement with the National Democratic Front? Suggested answer is no. A suit for injunction can amply be filed with the Supreme Court to stop the President of the Philippines from entering into a peace agreement with the National Democratic Front, which is a purely political question. Madarang versus Santa Maria. The President of the Philippines is immune from suit. Q. Katie filed an action against Tyrone for collection of a sum of $1 million in the Regional Trial Court with an ex parte application for a writ of preliminary attachment. Upon posting of an attachment bond, the court granted the application and issued a writ of preliminary attachment. Apprehensive that Tyrone might withdraw his savings deposit with the bank, the sheriff immediately served a notice of garnishment on the bank to implement the writ of preliminary attachment. The following day, the sheriff proceeded to Tyrone's house and served him the summons with copies of the complaint containing the application for writ of preliminary attachment. Katie's affidavit order of attachment, writ of preliminary attachment, and attachment bond. Within 15 days from service of the summons, Tyrant filed a motion to dismiss and to dissolve the right of preliminary attachment on the following grounds. 1. That the court did not acquire jurisdiction over his person because the writ was served ahead of the summons. Number 2. The writ was improperly implemented. And number 3. Said writ was improvidently issued because the obligation in question was already fully paid. Resolve the motion with reason. Suggested answer. 1. The fact that the writ of attachment was served ahead of the summons did not affect the jurisdiction of the court over the defendant. The effect is that the writ is not enforceable. Section 5, Rule 57 of the 1997 Rules of Civil Procedure. But as pointed out by jurisprudence, all that is needed to be done is to reserve the writ. Onnate versus Abrugar. Number 2. The writ was improperly implemented. Serving a notice of garnishment, particularly before summons is served, is not proper. What should be served on the defendant are a copy of the writ of attachment and notice that the bank deposits are attached pursuant to the writ. Section 7, Rule 57 of the 1997 Rules of Civil Procedure. The proper remedy where there is payment is a motion to dismiss, this is number 3, under Section 1, letter H, Rule 16. A motion to discharge on the ground that the writ was improvidently issued will not lie, since such a motion would be tantamount to trial on the merits of the action which cannot be ventilated at a mere hearing of the motion instead of a regular trial. The writ is only ancillary to the main case. Section 13, Rule 57. For procedure, read Mindanao Savings Loan Association versus CA and Davao Light and Power Corporation versus Court of Appeals. Q. What is the effect of absence of summons on the judgment rendered in the case? Letter B. When additional defendant is impleaded in the action, is it necessary that summons be served upon him? Explain. Letter C. Is summons required to be served upon a defendant who was substituted for the deceased? And letter D. A sued XX Corporation, XXC, a corporation organized under Philippine laws, for specific performance when the latter failed to deliver T-shirts to the former as stipulated in their contract of sale. Summons was or were served on the corporation's cashier and director. Would you consider service of summons on either officer sufficient? Explain. Suggested answer, letter A. The effect of the absence of summons on a judgment would make the judgment null and void because the court would not have jurisdiction over the person of the defendant. But if the defendant voluntarily appeared before the court, his appearance is equivalent to the service of summons. Section 20, Rule 14. Letter B, yes. Summons must be served on the additional defendant impleaded in the action so that the court can acquire jurisdiction over him, unless he makes a voluntary appearance. Letter C, no. A defendant who was substituted for the deceased need not be served with summons because it is the court which orders him as the legal representative of the deceased to appear and substitute the deceased. Section 16 of Rule 3. Letter D. Summons on a domestic corporation through its cashier and director are not valid under the present rules. Section 11, Rule 14, Rules of Court. They have been removed from those who can be served with summons for a domestic corporation. Cashier was substituted by treasurer. Q. A resident of Lingayen, Pangasinan sued X, a resident of San Fernando, La Union, in the Regional Trial Court, RTC of Quezon City, for the collection of a debt of 1 million. X did not file a motion to dismiss for improper venue, but filed his answer raising therein improper venue as an affirmative defense. He also filed a counterclaim for 80,000 pesos against A for attorney's fees and expenses for litigation. A moved or X moved for a preliminary hearing on said affirmative defense. For his part, A filed a motion to dismiss the counterclaim for lack of jurisdiction. Rule on the affirmative defense of improper venue. Suggested answer. There is improper venue. The case for a sum of money which was filed in Quezon City is a personal action. It must be filed in the residence of either the plaintiff, which is in Pangasinan, or the defendant, which is in San Fernando, La Union, Section 2 of Rule 4, 1997 Rules of Civil Procedure. The fact that it was not raised in a motion to dismiss does not matter because the rule that if improper venue is not raised in a motion to dismiss, it is deemed waived was removed from the 1997 Rules of Civil Procedure. The new rules provide that if no motion to dismiss has been filed, any of the grounds for dismissal may be pleaded as an affirmative defense in the answer. Rule on the motion to dismiss the counterclaim on the ground of lack of jurisdiction over the subject matter. Suggested answer. The motion to dismiss on the ground of lack of jurisdiction over the subject matter should be denied. The counterclaim for attorney's fees and expenses of litigation is a compulsory counterclaim because it necessarily arose out of and is connected with the complaint. In an original action before the original trial court, the counterclaim may be considered compulsory regardless of the amount. Q. RC filed a complaint for annulment of the foreclosure of sale against Bank V. In its answer, Bank B set up a counterclaim for actual damages and litigation expenses. RC filed a motion to dismiss the counterclaim on the ground that Bank V's answer with counterclaim was not accompanied by a certification against form shopping. Rule on the matter. Suggested answer. A certification against form shopping is required only in initiatory pleadings. In this case, the counterclaim pleaded in the defendant's answer appears to have arisen from the plaintiff's complaint or compulsory in nature and thus may not be regarded as an initiatory pleading. The absence thereof in the bank's answer is not a fatal defect. Therefore, the motion to dismiss on the ground raised lacks merit and should be denied. USC v. Surula. On the other hand, if the counterclaim raised by the defendant's bank answer was not predicated on the plaintiff's claim or cause of action, it is considered a permissive counterclaim, in which case it would partake of an initiatory pleading which requires a certification against form shopping. Correspondingly, the motion to dismiss based on lack of the required certificate against form shopping should be granted. What is the effect of an order of default? The effect of an order of default is that the court may proceed to render judgment, granting the claimant such relief as his pleading may warrant unless the court, in its discretion, requires the claimant to submit evidence. The party in default cannot take part in the trial, but shall be entitled to notice of subsequent pleadings or proceedings. Rule 9 of the 1997 Rules. Effect of failure to answer. Q. Distinguish between the effects of the failure to file an answer in a civil case governed by summary rules and in a civil case governed by the regular provisions of the rules of court. Answer. Under summary procedure rules, upon the failure to file an answer in a civil case, the court, motu proprio or upon motion of the plaintiff, shall render judgment as may be warranted by the facts alleged in the complaint and limited to what is prayed for therein, except as to the amount of damages which the court may reduce in its discretion. Section 5. Under the regular procedure, upon the failure to file an answer, the court shall, upon motion of the plaintiff and proof of such failure, declare the defendant in default. Therefore, the court shall proceed to receive the plaintiff's evidence and render judgment, granting him such relief as the complaint and the facts proven may warrant. Such judgment shall not exceed the amount or be different in kind from that prayed for. Sections 1 and 5 of Rule 18. Failure to prosecute. Q. X filed an action for reconveyance against Y. Y forthwith filed his answer and served it on X. A week later, X filed a motion to withdraw the action since he could not avail the services of a counsel. The court dismissed the complaint based on failure to prosecute. A month after, X instituted the very same action against Y. Y moved to dismiss the case, invoking res judicata. He alleged that dismissal of the first case had the effect of an adjudication upon the merits, since the court's order had no condition that it was without prejudice. The court dismissed the subsequent case on the ground of res judicata. Was the trial court correct? Answer: no, because the dismissal of the complaint and motion of X is without prejudice under Section 2 of Rule 17. The court erred in dismissing the complaint for failure to prosecute for an unreasonable length of time under Section 3 of Rule 17. Note: the plaintiff's failure to appear at the trial after he has presented his evidence and rested his case does not warrant the dismissal of the case on the ground of failure to prosecute. It is merely a waiver of his right to cross-examine and to object to the admissibility of evidence. Delaver v. Iturriaga. The provision of this rule shall also apply to dismissal of any counterclaim, cross-claim, or third-party complaint. When a declaration of default is proper, a judgment by default can be issued despite an answer being filed. 2012. A. Annulment of marriage. B. Legal separation. C. Cases where a party willfully fails to appear before the officer is to take his deposition. D. Declaration of nullity of marriage. Q. Circe filed with the RTC a complaint for the foreclosure of real estate mortgage against siblings Sisila and Charybdis, co-owners of the property and co-signatories of the mortgage deed. The siblings permanently reside in Athens, Greece. Circe tipped off Sheriff Pluto that Sisila is on a Balikbayan trip and is billeted at the Century Plaza Hotel in Pasay City. Sheriff Pluto went to the hotel and personally served Sisila the summons, but the latter refused to receive summons for Charybdis as she was not authorized to do so. Sheriff Pluto requested Sisila for the email address and fax number of Charybdis, which the latter readily gave. Sheriff Pluto, in his return of the summons, stated that summons for Sisila was served personally as shown by her signature on the receiving copy of the summons. Summons on Charybdis was served pursuant to the amendment of Rule 14 by facsimile transmittal of the summons and complaint on defendant's fax number as evidenced by transmission verification report automatically generated by the fax machine, indicating that it was received by the fax number to which it was sent on the date and time indicated therein. Circe, 60 days after her receipt of Sheriff Pluto's return, filed a motion to declare Charybdis in default, as Charybdis did not file any responsive pleading. 2015. Letter A. Should the court declare Charybdis in default? Answer is no. The court should not declare Charybdis in default because there was no proper service of summons. Section 12, Rule 14 of the Rules of Court applies only to a foreign private juridical entity that is not registered in the Philippines and has no resident agent in the country, and not to individuals. The service of summons by facsimile under said rule is therefore defective. A foreclosure of real estate mortgage is a quasi-in rem action. Thus, the court can render judgments as long as it has jurisdiction over the rest and any of the modes of extraterritorial service of summons under Section 15 of Rule 14 is complied with prior leave of court. There is unfortunately no showing in the problem that a prior leave of court was obtained before resorting to extraterritorial service of summons. Hence, the service of summons is defective. In a complaint filed by the plaintiff, what is the effect of the defendant's failure to file an answer within the reglementary period, 2013? The court may declare the defendant in default, but only upon motion of the plaintiff with notice to the defendant and upon presentation of proof of the defendant's failure to answer. When may a party be declared in default? A party may be declared in default when he fails to answer within the time allowed, therefore, and upon motion of the claiming party with notice to the defendant and proof of such failure. Section 3, Rule 9. Q. May a party who is present at the pre-trial of a civil case and assisted by counsel still be declared non-suited or as in default? Answer is no, because the only ground to declare a party non-suited or considered as in default at the pre-trial is failure to appear thereat. Other acceptable answer? Number 1. A party who refuses to obey an order of the court under the rules on deposition and discovery may be declared non-suited or as in default. Number 2. A plaintiff who fails to prosecute may be declared non-suited or as in default. Number 3. Under Circular 1-89 on mandatory continuous trial, failure to file a pretrial brief is a ground to be declared non-suited or as in default. Effect of an order of default. Effect of a partial default. Being declared in default does not constitute a waiver of all rights. However, the following right is considered waived. 2012. 1. Be cited and called to testify as a witness. Or letter B. File a motion for new trial. Letter C. Participate in deposition taking of witnesses of adverse party. And D. File a petition for certiorari. What is the effect of an order of default? This is repeated. The effect of an order of default is that the court may proceed to render judgment granting the claimant such relief as his pleading may warrant, unless the court, in its discretion, requires the claimant to submit evidence. The party in default cannot take part in the trial, but shall be entitled to notice of subsequent proceedings. State the cases falling within the exclusive original jurisdiction of the following. Letter A, Supreme Court. Letter B, RTC. Letter C, MTC. Answers. In letter A, petitions for issuance of writs of certiorari, prohibition and mandamus against the following: Court of Appeals, Commission on Elections and Bank, Commission on Audit, and Sandikambayan. Letter B, that's RTC. Actions in which the subject of litigation is incapable of pecuniary estimation. Number 2, actions involving title to or possession of real property or any interest therein, where the assessed value exceeds 20,000 or 50,000 in Manila, except forcible entry and unlawful detainer. 3. Actions in Admiralty and maritime jurisdiction where demand or claims exceeds 300,000 or 400,000 in Metro Manila. Number 4, matters of probate, testate or intestate, where gross value of estate exceeds 300,000 or 400,000 in Metro Manila. Number 5, cases not within the exclusive jurisdiction of any court, tribunal, person or body exercising judicial or quasi-judicial function. Number 6, civil actions and special proceedings falling within exclusive jurisdiction or original jurisdiction of juvenile and domestic relations court and court of agrarian reforms. Number 7, other cases where the demand, exclusive of interest, damages, attorney's fees, litigation expenses, and cost of value of properties, controversy, or is in controversy exceeds 300,000 or 400,000 in Metro Manila. Number 8, intra-corporate controversies under Section 5.2 of the Securities and Regulation Code. Letter C, actions involving personal property. This is for MTC. Property where the value of the property does not exceed 300,000 or in Metro Manila 400,000. Number 2, actions for claim of money where the demand does not exceed 300,000 or 400,000 in Metro Manila. Number 3, probate proceedings, testate or intestate, where the value of the estate does not exceed 300,000 or 400,000 in Metro Manila. Note, in the foregoing, claim must be exclusive of interest, damages, attorney's fees, litigation expenses, and costs. BP 129 as amended. Number 4, actions involving title to or possession of real property or any interest therein, where the value or amount does not exceed 20,000 or 50,000 in Metro Manila, exclusive of interest, damages, attorney's fees, litigation expenses, and costs. Number 5, maritime claims, where the demand or claim does not exceed 300,000 or in Metro Manila 400,000. Number 6, inclusion or exclusion of voters. Number 7, those covered by the rules on summary procedure, like forcible entry and unlawful detainer. Other civil cases except probate, where the total amount of the plaintiff's claim does not exceed 100,000 or in Metro Manila 200,000 exclusive of interest and costs. Number 8, those covered by the rules on small claims, that is, for example, actions for payment of money where the claim does not exceed 100,000 exclusive of interest and costs. And of course, if you're listening to this part, that means you have finished part 1, and I really thank you for your support. If you're not yet subscribed to our channel, go ahead and hit that subscribe button and let's study together. Part 2 is coming up. Thank you.